Sure, happy to.
So, Mr. Chair, sorry, can I just offer, just to clarify, you're asking the appellant to speak, and it's just limited to the issue of jurisdiction, and that's the purpose of this hearing.
Yes, so all discussion tonight will be limited to the jurisdiction.
Did we consider the motion for accepting this complete?
Yes.
Okay. And it was followed up. I know I need your second, but did you vote on it?
We did.
So we're good?
Yes.
Okay, well, thank you very much. My name is Joe Savitsky. I'm here, I'm from the Fulton firm of Perkins Thompson, and I'm here representing Karen and Larry Markson, who are the two sole members of Rockcraft LLC, the owner of the property in question here. We're here tonight because the town issued this 103-page long notice of violation regarding 2 conditions on the property. Just a little bit about the property. I know you've got a lot of paper in the form of the NOV and our appeal and the 2 memorandums that were submitted this evening, but it's a unique property. It's located at 9 Rockcraft Road. It's the only property accessed by that road. The property spans about 9.6 acres between Route 114 and Sedago Lake. There's about 850 feet of frontage on the lake. It's located in the village zoning district, and also a portion of the property falls within 250 feet of the limited residential shoreland district. There are a number of historic buildings that have been constructed on the property, and the 2 of which are relevant to the appeal this evening is one's known as Rockcraft Lodge, which is referred to in the NOV. I can say NOV, I mean the notice of violation, just so you guys are clear on the terminology. And we also refer to the building in that way in our appeal, so I'll just say the lodge, located up the hill, further away from the lake, and then another building, the boathouse, which is right on the lake. So I'll use those terms throughout my presentation and remarks this evening. So the lodge was built in 1916 as a private residence for the Spalding family. I understand the town's library bears the Spalding's name, and this past summer there was a fundraiser for the library at the property, which is one of the events cited in the NOV. The Spaldings owned the property for about 50 years or so, and then after that, in about 1963, the property came to be owned by the United Church of Christ. The church owned the property for about 50 years and used the property primarily as an event center for retreats, meetings, large gatherings, etc. The Marksons purchased the property from the church in 2011. By that time, the lodge was in need of significant renovations. The Marksons began the work of restoring the lodge to a single-family residence as the Spaldings had originally used it back in the early 1900s. Upon completion of the renovations to the lodge, the town's former CEO, Brandon Woolley, issued a certificate of occupancy authorizing the use of the lodge as a single-family residence. The lodge is a large building, and the property is very expensive to own. To defray some of these costs, the Marksons began making the property available to others as a vacation rental, as many dozens of other property owners in the town of Sedago have done for many years. Because the lodge and the surrounding grounds are both so large, they got 9.6 acres of space, it's uniquely suited to accommodate large groups of people. So many of the renters who have stayed at Rockcraft over the years have used the property for their own weddings. And also the fundraiser for the town library, which just occurred a couple of months ago, was also held at the property. So these types of activities have been going on for over a decade, not very intensely, on average about 4 or 5 or so weddings and events per year. This was information that the town requested from us, and we freely provided it. There was one year where there were a few more weddings, about 10 or so, due to sort of a spike that occurred in the wake of the pandemic, where a lot of people canceled their plans or rescheduled them. But that's what we're talking about here with respect to the lodge. It's about 4 or 5 times per year. There are weddings or similar events. And that is the violation listed as the first violation in the NOV. So that this occasional use of the lodge by guests for weddings violates both the town's land use ordinance and the town's shoreline zoning ordinance. So the fact that the NOV cites both the land use ordinance and the shoreline zoning ordinance on violation 1 lodge is relevant to the jurisdictional question tonight. But before I get there, let me just briefly discuss the boathouse. So the second violation alleged in the NOV relates to what is referred to the boathouse. The boathouse was built by the Spaldings in the 1920s to house their boat on the water level, and it had a large room on the upper level that included fireplace and electricity. The Marksons found church pews in the boathouse when they bought the property, suggesting that the church had used the upper level for gatherings and events. In June 2022, the town's former CEO issued a building permit to renovate the boathouse. In 2023, the former CEO issued a plumbing permit authorizing the installation of various plumbing fixtures in the boathouse. Also in 2023, the former CEO approved the connection of the plumbing in the boathouse to an existing septic disposal field located on the upland portion of the property, which the town had reviewed and approved in 2005, but was currently then not being utilized. So in reliance on these approvals, renovations to the boathouse commenced, and as of now are about 90% complete. The Marksons have voluntarily suspended all work on the boathouse and did so even before the NOV was issued, and are now awaiting those issues to be resolved with the town before they resume. So the building is currently vacant. The town has refused to issue a renewed building permit to complete the work as originally contemplated, and has also declined to issue a certificate of occupancy. So as a result, there is a brand new unused septic tank, ejector pump and feed line running from the pump to the existing disposal field that is lying in the ground empty. The town alleges in violation 2 that the tank, pump, and feed line were installed without proper permits and requires them to be removed. We thought that was all that the second violation alleged, was just those elements of the septic needed to be removed. But in the memoranda that were distributed this afternoon, apparently the town now also takes the position that the purported conversion of the boathouse to a single-family residence is also part of violation 2, which we don't find that in the plain language of the NOV. But the memo from the town attorney today takes the position that violation 2 pertains to, quote, Rockcraft's expansion, renovation, and alleged conversion of the boathouse to single-family residential use, which conversion is prohibited under 15C7 of the town's shoreline zoning ordinance. And she cites an email from Jeff Kalinich from the DEP supporting that position. What's not referred to in the memo is that email was in response to a letter that I had sent to the DEP requesting the DEP's interpretation of that particular provision in the shoreline zoning ordinance. So if you would like that letter, which I think is fair in response to the memo that the town attorney submitted this afternoon, it's right here. In it you will read that we always knew that conversion of the boathouse to any residential type use would require planning board approval, and it's all spelled out there in the letter. So we don't view, I don't read the plain language of the NOV to even address the residential use. I don't think it's properly before the board. It's an empty building. It's not complete. There's no certificate of occupancy. No one's using it right now, so there there can't really be any use of the boathouse currently. So that's just a minor diversion on that, but returning to the issue of the board's jurisdiction. So there's a provision in the town's shoreline zoning ordinance, which Attorney Wagner cited in his letter, that states, it's also stated right in the NOV, that, I'll read it just so everyone's clear what I'm talking about. Powers and duties of the Board of Appeals. The Board of Appeals shall have the following powers. And with respect to administrative appeals, such as the one we filed, the board has the power to hear and decide administrative appeals on an appellate basis. That's about planning board decisions, I'll skip that. The relevant language in 16H1A of the shoreline zoning ordinance is the last sentence of that provision. Any order, requirement, decision, or determination made or failure to act in the enforcement of this ordinance is not appealable to the Board of Appeals. So this is pretty clearly an enforcement decision. It's an NOV. And we would agree that to the extent the NOV relates to alleged violations of the shoreline zoning ordinance, that's not appealable to this board. However, there's a lot more that's said in the 103 pages of violations that the Marksons received. There are provisions of state law, of the land use ordinance of the town of Sevago, and also the subsurface wastewater disposal laws. With respect to violations of the land use ordinance, which are cited specifically with regard to the lodge, the use of the lodge, those decisions are appealable to this board, so that's why we appealed. Furthermore, there are provisions, I'm going to call them the rules. It's the state's subsurface wastewater disposal rules. That's kind of a mouthful, so I'm just going to say the rules. The NOV does not say anything about whether alleged violations of the rules may be appealed or the consequences of non-compliance with the rules. I think the parties are in agreement that the rules are administered and enforced at the local level by the CEO or the plumbing inspector, and there is a provision in the rules which provides that appeals made by local authorities must be made to the relevant municipal officials. We interpret this board as being the relevant municipal officials, so that's why we filed the appeal to this board. In the absence of any clear guidance within the NOV itself, that's how we interpret that language, but we would seek clarification from the board on that question. Part of the reason why we're here tonight. Finally, after consulting with a licensed site evaluator and also the state DHHS, we believe that violation 2, assuming it relates only to the removal of the pump, tank, and feed line, can be entirely resolved by submitting an after-the-fact application to amend the 2005 permit that authorized the installation of a septic system up the hill, which the boathouse is tied into. So we've offered to file that application for the towns that they would reject it. So if and when they do take that action, open question for the board is, should we appeal to you or not? So those are my opening comments. I'm happy to take any questions from the board. Thanks.
So you bringing in all the other construction and that, and to go beyond the scope of just a notice of violation, an enforcement issue, for us to hear it. I think we should be hearing it because of there's far more to it than just the violation.
There's a lot in here, and there's clearly parts of it that are not appealable, and other parts that are, I think, are within this board's jurisdiction. and others that are frankly unclear. So in the absence of that, there's a lot in here that we object to. We wouldn't want to lose the opportunity to raise those objections, so that's why we're here.
Just for
Sure.
clarification, you said that the conversion of the boathouse wasn't in the notice of violation, but on page 6, it does spell it out. Is there something I'm missing?
So that is something that would, that's more, I read that more of an interpretation of the ordinance that would apply prospectively, but it's not presently before the board because there is no single-family use of the boathouse right now. We interpret the actual violation to be the last paragraph on page 6 before the penalties. You're ordered to take action within 21 days of the receipt of this order to, 1, cause the treatment tank, ejector pump, and feed line connecting the boathouse to the former leach field to be excavated and removed. 2, sever any connection from the boathouse to any subsurface wastewater disposal system and permanently seal the same. And 3, draw up a revegetation and grading plan for review by this office in coordination with the Maine DEP to cause the area disturbed by the removal contemplated above to be returned to its previous condition. So, that's how we interpret it. Feel free to disagree.
The whole notice of violation for 2, though, is a complaint, isn't it?
I'm not sure I quite follow your question.
Well,
Mr. Chair.
The jurisdiction, that it's, the way that it reads, we're not allowed to hear appeals for complaints,
Oh, of enforcement decisions.
enforcement decisions. So,
Right.
so the whole, everything that is cited in number 2 is a complaint, isn't it?
Right. There are alleged violations of state law, of section 15K of the shoreline zoning ordinance, section 4A1 of the subsurface wastewater disposal rules. I think that was it in terms of violation 2. So those 3 things. So to the extent it's a shoreline zoning enforcement decision, those are not appealable to this board. Unclear as to the rest of it, and frankly, in the appeal, in the NOV itself, it says, to the extent, it opens by saying the violations of the SZO outlined above are not appealable to the Sedago Board of Appeals pursuant to section 16H1A. We agree. The next sentence says, to the extent this notice of violation and order may be interpreted to allege violations of the land use ordinance, separate and apart from the violations outlined under the shoreline zoning ordinance, you may have the right to appeal such violations within 30 days of the date of this written notice to the Board of Appeals. So that's why we appealed, because of that language. We got a memo today saying elements are definitely not appealable to this board, which could have been spelled out 2 months ago, but here we are.
Anybody have anything?
I have a question. Okay. So, on page 6 of your appeal, where it says violation number 2 alleges the septic tank ejector pump, feed line running from the ejector pump to an existing permitted leach field were installed without a permit and must be removed, and that we should vacate this allegation in the notice of violation. Going through this, I did not actually see a permit that discussed attaching it to the leach field or any type of subsurface wastewater disposal. Could you direct me to that permit?
Sure. Well, first of all, I think we're only discussing the issue of jurisdiction tonight. So when we get into the merits, if you think the board has the merits to answer that question, I'd be happy to speak to it. In the NOV, in our appeal, we cite the building permit that was issued, number one, and not appealed. The plumbing permit that was authorizing the fixtures to an existing permitted disposal field that was installed in 2005 and available for connection. So I think the town's position that there is no permit for the connection is the result of an unchecked box on the form. But we could get into that in a later meeting if that's the board's decision to assume jurisdiction over that.
So, well, I was asking because, so part of the determination of jurisdiction is related kind of to specifics of the violation. And so I was trying to understand whether it's an enforcement issue or
Or a permitting issue.
Or a permitting issue.
Sure,
Yeah,
fair question. I think it can be interpreted as both.
okay.
You referenced a ordinance, 6-1 something?
So there's two Sebago ordinances that are cited in the NOV. One's the shoreland zoning ordinance, refer to it as the SZO. But the town also has a separate land use ordinance that governs zoning generally. So both have provisions related to commercial use. So the town cited both the land use ordinance.
Do you remember what it was, so that I might look at it?
So the appeals, what
The appeals.
the appeal section. So in the SZO, it's 16. Let me get it exactly right here. Stephen, I think, also cited in his memo.
Yeah, if it's easier for the board, in the Rudman Winchell memo, it's the excerpts of all the relevant jurisdictional provisions of the ordinance, so that might be a little bit easier than going through the ordinances themselves. But if you are looking at the ordinance itself, it appears on page 42.
Does relevant law pertain to jurisdiction?
That's right.
Appeals shall hear any appeals or Title 28, Section 10. Where would I find Title 28, Section 1054?
So where are you referencing that?
I'm reading this at the bottom of prevalent laws, relevant laws pertaining to jurisdiction. Right at the bottom of that paragraph. Any board of appeals shall hear any appeal submitted to the board in accordance with Title 28A, Section 1054, or 1054.
Right, so I'll suggest to you that that's not relevant for the discussions today. I don't think you need to consider that, but I can certainly pull up a copy. I don't have them handy for me. That's a specific appeal provision, but you've got specific procedures in your own zoning ordinance and land use ordinance that control. So those aren't relevant to the question of jurisdiction, in my view. The other parties may have other views on that.
I just looked it up, it relates to liquor licenses. So,
Say again?
it relates to liquor licenses. So not relevant to this particular.
So could you summarize what you think that we should be hearing? What we have
That is up
jurisdiction?
to the board to decide?
No, but
I think the parties agree that to the extent the NOV is a shoreland zoning ordinance enforcement decision, the NOV is, those violations are not appealable to this board. I think it's pretty clear that portion of the NOV is not. The land use ordinance violations that are also cited in the NOV definitely are appealable to this board. With respect to the subsurface wastewater disposal rules, those are state regulations that are administered and enforced locally by the CEO or plumbing inspector. There is an appeal provision in those rules that says appeals of local decisions shall be made to the relevant municipal officials.
all right, so you're in
I would interpret this board as being, typically a board of appeals would be the relevant municipal officials, so. But I believe that's for the board to determine.
So you're seeking us to not throw out violation 2 altogether under the shoreline zoning jurisdiction, but to hear 1 and 2.
I think it's up for you to decide. We're here out of an abundance of caution because it's admittedly not clear with respect to the rules. So I think there's authority to suggest that both 1 and 2 could be heard by this board.
Mr. Chair.
Sure, yeah.
Sorry, I don't mean to interrupt you.
Okay. I would actually like to make a motion to go into executive session to clarify portions of the land use.
So let me just say this first. I think we're stretching a little bit into some deliberations. I think first, though, we should, what we're doing now for the chair's direction is any questions of the appellant's attorney. Then you should move over to the code enforcement officer's attorney to have them present their side, and you ask any questions of them. then open it up to the public comment if there's any comments pertaining to jurisdiction. And then one final opportunity for the appellant to weigh in. And then we'll close that public hearing, and then we'll get into deliberations. So then at that point, if you have any questions for me, we would do that during deliberations.
Okay.
If that makes sense.
Okay. Does anybody else have any questions?
No.
I don't have any questions. I just, I thought we were here to decide this evening on whether or not we have jurisdiction to even hear violation 2, correct?
It's jurisdiction on the appeal altogether. So
On the appeal altogether.
The appeal is an appeal of the notice of violation. The notice of violation asserts 2 violations. So I think it would be helpful at this point, if the board doesn't have any further questions of Attorney Savitsky, to turn it over to Attorney Chow.
Perfect.
Anybody have any questions? No. Has anything else to add?
Not for now, but happy to answer questions as they come up.
Okay.
Thank you, Mr. Chair and members of the board. I'm Amy Chow, as I said before, and I'll try to keep this fairly brief. I think actually on the issues of jurisdiction, the parties are closer than we might think. Perhaps the answer with respect to whether this board has jurisdiction to hear violation 2, we disagree on that. And I will try to confine my comments to why I do not believe the board has jurisdiction to hear the entirety of violation number 2. I did hear Mr. Savitsky say, and I agree with him wholeheartedly, that the shoreline zoning ordinance enforcement decision aspect of the notice of violation, or the NOV as we've been calling it, is entirely not appealable to the Board of Appeals. And your ordinance, the shoreline zoning ordinance, spells that out very specifically. And I think perhaps where we differ, what I would say is that all of the violations that are alleged in violation number 2 of the NOV pertain to violations in the shoreline zone, governed by the shoreline zoning ordinance, and are alleged to be in the notice of violation only violations of the shoreline zoning ordinance, not the land use ordinance. Okay? I think that allows you to decide to remove violation number 2 from your jurisdiction. However, Mr. Savitsky argues that, well, what about the subsurface wastewater disposal rules, which are state rules? Might the board have jurisdiction of that? And for a number of reasons, I believe the law is very clear that you do not. The first is that to the extent the subsurface wastewater disposal rules, that's a mouthful, I'm sorry, the rules govern or are related to the violations that are occurring in the shoreline zone in connection with the boathouse and the installation of the septic tank, ejector pump, and feed lines, the tank of which is located within the shoreline setback and should not be there without a variance under those rules. So there's a violation separately of the subsurface wastewater disposal rules. But your shoreline zoning ordinance, section 15C7, says specifically that, I'll paraphrase, I can get to the ordinance language, but it basically says that any sewage disposal system that's located in the shoreline zone must comply with those rules, those state rules. So there's a violation of the shoreline zoning ordinance because those rules say you must have a permit for every component of a subsurface wastewater disposal system. And there is no permit, and Mr. Savitsky's administrative appeal actually concedes this. There is no permit for installation of those components. There is no permit that allows the connection of the fixtures that are the plumbing fixtures located in the boathouse that I would argue are for single-family habitation to connect to the septic tank, ejector pump, and feed lines that were installed all without a permit and then connected up the hill to an existing leach field. You will find no permit in the record for that. The subsurface wastewater disposal rules say you need a permit for that. There was no permit. The reason, the issue of whether there has been a potential conversion to a single-family residence of this boathouse structure. I'm going to go into a little bit of the background just because Mr. Sadisky did, although I know we're here only on jurisdiction. It's interesting, as you know, this property for years was owned by the church, and there were events that took place in this lodge on this property. It's important, I think, for the board to understand that Mr. Sadisky's clients have said their intent was, and they did return the use of the property to single-family residential use. When they bought the property, they received a certificate of occupancy for single-family residential use of the lodge and of that property. The reason that's important to your consideration, and I'm a visual person, so if you'll indulge me, I did in my submission today submit this to you. And the reason I did that is because I thought it was important to show where the various features are that are in this notice of violation. The red hash line is the village district. That is the district. You have village district, you have rural district, you have districts under the land use ordinance, and the entire parcel is located in the village district. The green part is the shoreline zoning area, which is in this area called the limited residential shoreline zoning district. It's important, I think, for you to realize that this green area is governed independently by the shoreline zoning ordinance. And while the property as a whole and a portion of the lodge occurs in the shoreline zone and a portion occurs outside of the shoreline zone, I'll get to violation number 1 in a moment, it's undeniable that the entirety of the boathouse is located in the shoreline zone and governed by, and there are enforcement provisions to ensure that this use and what can be made of this boathouse complies with the shoreline zoning ordinance. The code enforcement officer found that it did not. And you'll see in the notice of violation that she alleges violations of the shoreline zoning ordinance and not the land use ordinance. And therefore, this board should not have jurisdiction of that. Another reason why this board does not have jurisdiction of violation number 2 in its entirety, meaning shouldn't be considering any part of the expansion, whether plumbing permits were issued, whether no permits, septic permits were issued, is that there is a statute which is referred to in Mr. Wagner's memo to you on page 2, and it governs this very situation. And it's Title 30A, MRS Section 2691-4. And in my memo to you today, I outlined why I believe this statute governs on all fours the jurisdiction of this board. Boards of appeals are what we call creatures of statute. Their powers and your authority is limited. It's limited in 2 ways. Either a statute tells you what you have jurisdiction over, and there is a statute that allows you to hear variance appeals. That is governed by statute, okay? The only other source of authority you will have to determine what you have authority to review, I'll read it. It is conferred by statute. No board of appeals may assert jurisdiction over any matter unless the municipality has, by charter or ordinance, specified the precise subject matter that may be appealed to the board. Now, I will submit to you there is nothing in any of your ordinances that allows the Board of Appeals, and I bet you haven't reviewed the issuance of or denial of plumbing permits or septic permits alone. And it does not grant jurisdiction over that specific matter. And furthermore, this section of the statute goes on to say that absent an express provision in a charter or ordinance, that certain decisions of its code enforcement officer in the absent and express provision that certain decisions of its code enforcement officer are only advisory or may not be appealed, a notice of violation or enforcement order by a code officer under a land use ordinance is reviewable by the Board of Appeals. So that's sort of saying the negative. So if your ordinance were silent on whether an enforcement decision by your code officer could be appealed to the Board of Appeals, this statute says you can take jurisdiction of that. However, in this case, your ordinance is not silent. It's very clear. It's very clear that enforcement decisions of the code officer are not appealable to the Board of Appeals. And so, notwithstanding what the subsurface wastewater disposal rules say generally about, oh, municipal decisions are generally, or local authorities' decisions about subsurface wastewater disposal decisions are generally reviewed by municipal officials, that's a passing reference. That's not a grant of jurisdiction, because this statute says you have to look at whether there's an ordinance or a charter provision, not a set of rules to determine whether you have jurisdiction over those. So, sorry for the long-winded legal analysis. I think it is very clear, though, that violation 2 is not reviewable by this Board of Appeals. I do want to say something about violation number 1, because there is probably some agreement on that. I do agree with Mr. Savisky that because a portion of this entire parcel that we believe was devoted to the unauthorized commercial wedding event use of the property, we do believe that violation 1 is reviewable by the board. And to the extent that the board may need to call upon evidence of how the entirety of the property is used, including the areas of the property in the shoreline zone, it's my understanding from the code officer that many of the weddings that have been held here for 150, 200 people occur not only within the lodge, but occur in a tent that's in the shoreline zone. I understand that those may be facts that the board may find relevant to determining whether overall there's an unauthorized commercial use here. Your land use ordinance says if you're going to operate a commercial use in the village district, you must go to the planning board for site plan approval. Your shoreline zoning ordinance says you may not operate any new commercial use anywhere in the green in the shoreline zone unless you're grandfathered. In this case, the Marksons have conceded that the event space that may have been grandfathered by the church's use of it many decades ago lapsed and was replaced with a single-family residential use. So under no circumstances should the shoreline zone in this area be allowed to be used as a commercial use. But that's, I'm getting ahead of myself, that's not a jurisdictional issue, but I wanted to go on record that we are not here tonight to say that the Board of Appeals cannot review violation number 1. Thank you.
Violation number 1 or number 2?
I said it in the double negative, I'm sorry, it was confusing. We are prepared to present a case and have the board hear the administrative appeal on violation number 1 alone, not violation number 2. Thank you.
Question for you.
Yes.
Would it be appealed to the Board of Appeals, violation number 1, or would it be reverted back to the planning board for full site plan review?
No, it would, because it's an enforcement decision.
Yeah.
And it's, you're reviewing the code enforcement officer's decision. I believe you would be determining whether or not the code enforcement officer's decision was substantiated and supported by your interpretation of the ordinance. I'll leave it to Mr. Ward's counsel on whether there's a remand. I did want to make one final point, I'm sorry, I said I was finished. Another reason I believe that violation number 2 should not be heard by the Board of Appeals is that the appellants here have simultaneously filed an appeal in court. They have appealed the entire notice of violation under Rule 80B to the Superior Court, and that is now pending. So to the extent that violation 2 will be heard by anybody, it should be heard by the Superior Court and not this board. Thank you.
So maybe I missed something that you said, but if we don't have jurisdiction to hear number 2, why do we have jurisdiction to hear number 1?
Well, there are violations. I think the simple answer is if you go to violation number 1 and look at the violations, they include a violation of the land use ordinance. They are operating, we allege.
The property
commercial
close to the
use.
road, yeah.
Yes. We believe they're operating a commercial use, and they haven't, it needs to be permitted in the sense of going to the planning board for site plan review. They haven't done that. And so we believe that that can be heard by the board.
Does anybody else have any questions?
I'm not sure it's a proper question. So, tell me if I shouldn't ask this or not, I honestly don't know. So if I have a violation in the shoreline zone, I have nowhere to go but Superior Court? So if I care to appeal it, am I to understand that correctly? Rather than Sebago?
Not if it's a permit situation. So, and your counsel can answer this, but I'll
Okay.
take a shot at it.
As I said, if
I
it was a
interpret
bad
this question
question,
to you.
tell me
so-
straight up.
Okay.
I'm okay with
Yes.
that.
But if you want me to answer it, that's your call.
So, Mr. Plummer, the board wants to go to page 4 of the Rubin and Winchell memo. If you look at 16H1.
Hold on.
Yeah, I know. So, I won't read you the section, but this section is broken into 2 parts. And it basically says that if the code enforcement officer issues or refuses to issue a permit in the shoreline zone, that is appealable to you. However, in an enforcement decision, the issuance of a notice of violation by the code officer, you're violating the ordinance. It's not whether a permit should be issued or not issued. You are, what's a blatant violation in the shoreline zone? You're violating the ordinance because you built your building too close to shoreline setbacks, let's say, or you've cut down too many trees. And usually most code enforcement officers will go to the violator and have them, enter into a consent agreement or make some amends. But sometimes things break down, and when they break down, code enforcement officers have the authority to issue notices of violation that say, I tried the informal way, you still haven't corrected the violation, this is a violation. It's serious because it's in the shoreline zone. And I don't know if this is helpful, but this exact language comes out of the minimum state shoreline zoning guidelines. And I have to think, this is just my speculation, that DEP felt it was very important in the shoreline zone for enforcement decisions to be, heard, and perhaps heard by, as a matter of first impression before the court and not the Board of Appeals. That's just speculation on my part.
I agree.
Seems weird to me, but
Yeah, if you want me to answer it my way, so it's not just
Please.
me agreeing. Sure. So the question that you would ask, which I think is a fair one, is you would ask if your only remedy for an issue in the shoreline zone is filing a lawsuit in Superior Court. And I think I would have that same question, right? Because that's expensive. You got to jump right away to court. And as I understood the answer, which I agree with, no is the answer to that question. It depends on what is being appealed. So if you look at section 16, because as Attorney Chow said, a Board of Appeals is a creature of limited jurisdiction. It's not a general body of jurisdiction. So you only have authority to hear disputes when there's something in your ordinances that specifically say you can. There's one statutory issue that's not an issue here, so we don't need to talk about that. But there are different types of appeals, right? You're probably most used to dealing with variances, and those can arise out of the shoreline zone. Then there's something called administrative appeals. There are sort of two flavors of administrative appeals. You could have an appeal of a decision to issue a permit or not issue a permit. That would be appealable, as I interpret your ordinances, to this board. But your ordinance in the shoreline zone specifically says that enforcement decisions are not appealable. So to the extent that you make a determination, and this is your determination to make, which is why I didn't answer it in my memo, to the extent you make a determination that the issuance of the notice of violation is an enforcement decision, then I think it's quite clear, and I think both parties agree, an enforcement decision that arises out of the shoreline zoning ordinance is not appealable. So it would only be in that specific circumstance of an appeal of a notice of violation that the ordinance says that would not be appealable.
Thank you.
Anything else? Anybody else? Do you have anything else to add?
I don't, thank you.
Now would be the opportunity if there are any members of the public who have any comments pertaining strictly to the issue of jurisdiction, which, as you've probably gathered from hearing attorneys talk more than you probably wanted to ever hear attorneys talk tonight, it's a pretty technical procedural issue, so it's not really about the merits. It's just about this legal issue of whether the board has the right to hear this case.
Okay, well, nobody from the public? All right, Mr. Savisky, would you like to speak again?
Well, I mean, we're here because we got a 103-page NOV, which is the largest NOV I've ever seen in my professional career. There's a lot in here. There's 7 pages of narratives. At its core, this is a shoreline zoning issue. I will say that we've been trying to resolve this for months, and Marks have offered to submit an application to the planning board to review this conduct, whatever you call it. We disagree that it's commercial, but would nevertheless be willing to submit an application to the planning board. That proposal was not accepted by the town. So I will leave it to the board to determine the extent to which you have jurisdiction over this. It's clearly more than just a shoreline zoning enforcement matter, in our opinion. I don't know what to make of the violations of the wastewater disposal rules, and the town could have made it easier on you by omitting those. references and just making this purely a shoreline zoning matter would have made the answer to tonight's question easier, but I don't think I have any further comments at this time.
Can I say something?
Sure.
Is that okay? And I know this is jurisdictional, but because Attorney Chow brought up the issue of weddings, I do want to say again that for over 10 years, on average, we've had 5 weddings a year. The town has approved liquor permits for many years. This was never raised as an issue until we started having an issue with the boathouse. When this was brought up to us many, many months ago, on at least 2 or 3 occasions, we offered to go before the planning board. We said we're happy to talk about weddings. And the town never pursued that with us. So it's really frustrating that, you know, at the last minute, a notice of violation is issued to us where they said you have 48 hours to stop, which ironically was, you know, 3 days before we had a wedding coming up, but 21 days to resolve the boathouse issue. So it's obviously, it's upsetting, it's disappointing. What's very upsetting is that we're all here spending a gazillion dollars with attorneys, no offense, Joe, where this could have been resolved months and months ago. We have done everything we can to work with the town. You folks did not have any of the documents related to Rockcraft and all the permits that we applied for that were given to us by the town, by the DEP, 3 PBRs issued by the DEP, including for the expansion. All along, we did everything that we're rule followers, and we did everything that we were supposed to do. And we've tried very hard to work with the town, and I feel like every time we've tried to work with the town, something more punitive is presented to us. And I would rather be taking all this money that's going towards the attorneys and have that go to the food bank at the local church. We shouldn't all be here right now having this conversation. This should have been resolved months and months ago. And I apologize that I'm probably talking about something that's not jurisdictional, but it's just astonishing that we're in this position right now. And I hope that in whatever capacity we can get this resolved, put this behind us. I love this town, I love these people, I love everything, you know, we are retiring here in a couple of years. And I hope that, again, we can put this behind us and that the town would work with us. We've tried to be very collaborative.
Mr. Chair, may I just briefly
Okay.
be heard? I know this is in rebuttal, and just respectfully, and I know issues often can be emotional, but I would just respectfully suggest that settlement discussions of settlement offers are not obviously within the purview of this board. Your jurisdiction is very narrow. The code officer issued a notice of violation. Your job, if you find that you have jurisdiction over one of the violations, is to hear the evidence and decide under the ordinance whether the code officer was correct in issuing the notice of violation. I will tell you, I've represented communities for a long time, and it has always been my experience that communities such as this one work really hard to try to work with their residents. This is not just regular litigation. We understand that we are all part of a community, and it doesn't serve anyone to be in endless litigation. I would just simply suggest that the reason we're before you is that we have not been able to reach a resolution, and that this board will not play a part, should not play a part in that. Thank you.
I just want to draw a fine line under that. Discussions about the litigation, discussions about settlement, all of that wouldn't be within the purview of the board. You're just limited to, once we get past this jurisdiction issue, you are limited to just, did the code enforcement officer make an error in issuing the violations.
Okay, if there's no more comments from anybody, guess we will continue the public hearing and deliberate and decide if we have jurisdiction in the shoreline zone.
Can I just clarify that? So what the board is doing is continuing the public hearing portion, and that's just a procedural nicety, rather than close it, we're continuing it, and it will resume at the next meeting to consider the merits. But for purposes of today, we're essentially shutting down the public hearing. Now it's the board's opportunity to discuss amongst itself. If it has any questions for me, you can ask me questions. I can give you those opinions.
Board member, I can't quite read your last name.
Cahoon?
Cahoon. You were in the middle of making a motion for an executive session, presumably to ask questions of me, and I, probably not as artfully as I think I was in my head, steered you away from that. So I just want to direct you back to that, just to say that you're welcome to make a motion to enter into an executive session. Presumably it would be to discuss with legal counsel. That would require a 2/3 of the board to agree. I'm going to encourage you not to do that if the reason is to ask me questions about what this means. What does the statute mean? What's my opinion on what the statute means? How should you go about making your decision? Because if we were to go into executive session and I was to give you that opinion, I would have to come back here and give that same opinion to the public anyhow, because to the extent that you rely on it, it has to be part of a public session.
I think the book's pretty straightforward.
Yeah, I agree. It says we cannot hear it. It's not appealable to the Board of Appeals.
It says enforcement decisions are not appealable. She made some enforcement decisions, so,
In the shoreline zoning.
in the shoreline zone.
So unfortunate, but yes, it's black and white for the shoreline zoning for violation 2. I think the nuts and bolts aspect of trying to pull apart different plumbing codes and say you can appeal this and appeal that, but it all boils down to you still need approval for the entire project under shoreline zoning to even move forward with the plumbing. So you can't appeal the plumbing, because if you win that appeal to be heard on the plumbing aspect and the plumbing ruling, you still don't have approval in shoreline zone on violation 2. Violation 1, I would like a little bit more clarity on what the process would be. If they appeal violation 1, which I also see as kind of black and white, there's not allowance for commercial in the shoreline zoning. So what are they appealing?
I think it has to be, part of that would be determining if it is a commercial use. I mean, when we hear one,
Violation 1.
the town is saying it's a commercial use, but that's something we have to determine.
That was my
That seems
understanding.
like it's a huge can of worms. If we determine, again, stop me if I'm stepping over. If we determine that it is a commercial use, what about the neighbors down the street that rent out their property? Is that a commercial use? What about the neighbors down the street that rent out their property? Is that a commercial use? A lot of people rent out their.
But that's something we
That would be in the
take up.
future hearing.
One, we have to
Yeah,
decide.
I understand that, but I'm just, that's,
And I don't think it's the renting
It's a big
out
can of
of
worms.
the property so much as hosting the events that determines it and deems it into a commercial category. Why it's unfortunate, I know the history of the building and the property, and I know it was used for years, but then it went unused. So I hate the term grandfathered, but it was a grandfathered use, but that grandfathering was eliminated. So you would have had to get site plan approval again. And I just, if we hear violation 1, if we determine that it is a commercial use, they go in front of the planning board after the fact and get site plan approval. Planning board, it's black and white, commercial use is not permitted in the shoreline zone. So without a language amendment,
So I don't want to go too far. Let's do you
Well,
guys
that's
back. Yep, yep.
But I
but
mean,
what are we appealing?
to focus on what we're doing, I mean,
Yeah.
if we agree that they don't have, that we can't hear an appeal in the shoreline zone, then that takes violation 2 out of it. But
Yes.
we can still hear one.
Violation 1, and make a determination if it's commercial.
So can I offer a suggestion? I don't want to get in the way of your deliberations. Part of my job is to walk you through these deliberations and help you articulate specific factual findings that lead to your ultimate conclusion about what jurisdiction you do and don't have. So sometimes I'm going to be a little bit annoying and I'm going to insert myself and ask you to flesh out some thinking and see if everybody agrees. And the reason I'm doing that is I'm taking notes and going to try to compile that all into a motion that I'll read back to you after your deliberation. So I apologize for me sort of interjecting to flesh some of that out. So that's my throat clearing for, why don't you guys start with, what is the nature of this appeal? I previously had described it as, I said you would have to make a determination if you agreed that this was an enforcement action. Or is it an action in order of the code enforcement officer? Is it an enforcement action? Characterize what you have in front of you first. And that's going to help you apply the ordinance language to determine what is and is not within your jurisdiction.
Well, I think both violations are enforcement actions. And we have, violation 1 is partly in the land use, the village zone, and comes under the land use ordinance. I believe we have jurisdiction over that, it would seem like, but in the shoreline zone, we do not.
I don't know what to think about violation 1, just because the grandfather statement came up. I was re-educated on grandfather rules recently, and it's within a year old. So if I tear down, this is just how I equate it. If I tear my building down and I don't replace it within a year, it's not grandfather anymore. But, so if I had a picture of a building that was built 50 years ago, that building's been gone for 30 years, that's not grandfatherable. But if I tore it down less than a year ago and decided I wanted to rebuild it there, I can rebuild it. So the grandfather rule, as I understand it, is a year old, less than a year old, or a year less. Is that correct, or is that not correct?
That's very wide.
A very generalized description, and you have what we refer to as non-conforming, lawfully pre-existing non-conforming uses or structures, which is what your ordinance refers. It doesn't use the word grandfathering, it talks about lawfully pre-existing non-conforming structures. And I'm going to steer it back to jurisdiction. And so before you can even get to those questions, you have to look at your ordinance to say, okay, we have, so what I'm hearing is everybody agrees this is an enforcement action. So then you have to look at, you start with violation 1, and violation 1 you've heard includes, I think everybody agrees, it includes some parts based on the land use ordinance and some parts based on the shoreline zoning ordinance. So then you want to ask the parts based on the land use ordinance, do you have authority to hear those? I think the chair suggested yes, because the land use ordinance doesn't say you can't. But then what I'm hearing is people seem to be in agreement. as to the shoreland zoning ordinance, because it says you cannot hear an enforcement action, you would not have authority to hear the parts of violation 1 that pertain to the shoreland zoning ordinance. Is that an accurate summary of what everybody's saying?
I guess where I was trying to go with that little spiel I just made was does the business aspect of Rockcraft fall under that same idea? Or does it not? I don't know.
Well, only if it's found to be a commercial use.
We would have to.
I mean, the code enforcement officer is
If it was commercial, and then it would be grandfathered or not?
So why don't, if I can offer this suggestion, why don't you turn to the notice of violation and look at violation 1 and make some findings as to the ordinances in violation 1 that are alleged to be violated.
isn't that getting away from the jurisdiction?
Nope, it's
No,
the
because
first part of that.
it's gonna
You
be
need
whether
to
or not
identify,
land
you
use.
need to make a finding that violation 1 concerns enforcement of the land use ordinance and the shoreline zoning ordinance. That's at least what I think I heard you all say, and I just want to make sure that that's accurate.
So it's going to be on page 4. So right there, this is right there, our right. That's what our right. And we have these ordinances that would allow them to be able to. Now, if it's a commercial
So
business, however.
you do need to talk loud.
Yeah, yeah.
Oh,
That can
sorry.
pick you up.
Oh, okay, so,
I could hear.
related to violation number 1. The appellate is arguing that they have short-term rental use allowed under our land use ordinance. So, we need to agree if because that is a possibility, then that would fall under one of our land use ordinances. Related to commercial use in shoreland, that might not necessarily fall under our purview, but we need to make a determination tonight about jurisdiction based on that, but then in a future hearing, we would determine if what they're doing would be considered a short-term rental or if what they're doing would be considered a commercial use. That's my understanding. So that's just that part related to using the home. My understanding, and Mr. Wagner can correct me if I am incorrect, but related to the grandfathering aspect, and I could be incorrect here, but in 2011 when they purchased it, and then they did the remodeling, and at that point they made it into a single family residential building, at which point then it was no longer a function facility but a single family use. So grandfathering would only go back as far as when that occupancy permit was allowed, which was longer than a year ago.
But that doesn't have to do with our decision tonight.
No,
Right.
I was just explaining the grandfather aspect. So violation 1, I feel as though violation 1 is under our purview because they're suggesting that they're using it under one of our allowed land use ordinances. There is an argument from our CEO as to whether or not that is or is not. And so that's where we would want to get additional information from a hearing to to make a determination as to which party we feel as though is correct in their explanation of use. You're welcome.
So you think we have jurisdiction on one and not on two?
I feel as though we have jurisdiction on one. When I asked earlier about the permit aspect, that was me trying to make a determination in my brain whether it was an enforcement issue or a permit issue, because enforcement issues are not allowed, whereas a permit issue may be allowed. But based on the information I've received, I feel as though we do not have purview for violation number 2, but that we do have for violation number 1. My personal opinion.
Anybody else?
I think if it's, everything's in shoreline zoning, and we don't have any jurisdiction in zone.
Is everything in shoreline zone?
Yeah, 99% of it. Everything that we're talking about, the boathouse, I don't know.
But the boathouse is violation 2. So if we determine that we
And
don't
the
have that,
lodges
that's
in
irrelevant.
shoreline zoning except for
But
port.
look at all this.
There's no buildings in there.
Do you see the
Right,
chart?
Yeah, the porches are shoreline zoning.
So I think it may be helpful for me just to recap to you what I think the parties are both in agreement on. I think the parties have stated that they agree that the board does not have jurisdiction over enforcement actions arising out of the shoreline zoning ordinance, but that the board does have jurisdiction over enforcement actions arising out of the land use ordinance. I think the parties agree, and I think at least a few board members agree, that the notice of violation 1 asserts that there's a violation for having a commercial use under both the land use ordinance and the shoreline zoning ordinance. So are you all, so I guess the question for you, because I'm getting 2 different answers on the board. I think some people think that the board has jurisdiction over the entire notice violation number 1. And some folks are saying that, no, we only have jurisdiction over the aspects of violation 1 that are based on the land use ordinance. Or do I have it wrong and you are all saying that piece?
I think we have jurisdiction over 1, but we don't over 2 because it's in the shoreline zone.
What are you reading, Laurie?
So in our shoreland zoning ordinance, if you guys have it available, I would direct you to page 16, which gives you land uses that are not allowed in the shoreland zone. And so if you, well, it's specific. So we have shoreland and we have limited, so we have limited residential, which would be shoreland. And unless I have missed it on this form, I do not see anything related to short-term rentals.
So I think that's getting into the merits.
Yeah.
Yeah, it's going in a different direction.
But what
I
I'm
get you.
trying to
I get
point
you.
out is that would be something that they could argue to us.
I agree.
So, because I think there was like, so maybe I'm misunderstanding, but I think that maybe there was a question about, because it's all in shoreland, like can we do nothing? And there are things that are allowed in shoreline. And so that's the determination that we would need to make at a later date. That's my understanding.
It's a single-family property that has weddings. You don't need a permit in Sebago to have a wedding. What's being alleged is that
There's commercial activity.
it's a commercial operation. It's gone from being a single-family residence to a commercial property, but that's something that we have to determine, but not tonight. We're just trying to figure out, can we hear it? What can we hear in this complaint? And it seems like we're in agreement that we can't hear two because it's in the shoreline zoning ordinance, but we can hear one because it's partly in the village zone, which is the land use ordinance. So if we can come to an agreement on, you know, what's our jurisdiction, what do we have?
I'll agree that I don't think we have jurisdiction on number 2, but I think we have jurisdiction on number 1.
So why don't we focus just on number 1 for right now, and I'm still hearing 2 different answers. Mr. Chair, what I heard you say is you're concluding that you have jurisdiction over number 1 to the extent that it's dealing with violations of the land use ordinance, but not the portions dealing with the shoreline zone.
Yes.
ordinance. Is that correct?
Yes.
Okay. Does everybody agree with the chair on that?
Yes, I do.
And can I just summarize what I think I heard as some of the pieces of reasoning and the facts you've made to support that conclusion? You said it's because it's in the violation, 1, is part of an enforcement action. And an enforcement action is a decision or order of the code enforcement officer. Under your land use ordinance, you have jurisdiction to hear appeals of decisions of the code enforcement officer interpreting or applying the land use ordinance. But under your shoreline zoning ordinance, you explicitly do not have jurisdiction to consider enforcement actions. Therefore, you have jurisdiction to hear the appeal concerning violation 1 only as it pertains to violations arising out of the land use ordinance. Is that correct?
That's all
Yes.
black and white.
That's what I'm
Maybe
hearing.
we just got
Yep.
waylaid one way or the other. That's all in black and white, right?
It's probably been on a board.
All right, well, does anybody want to make a motion?
So what you're suggesting, we'll split it into 2 motions then, essentially. 1 motion dealing with just violation 1, and then you'll, because I think we need to work out a little bit of the rationale for violation 2, in my opinion. I told you I was going to be annoying. I just
So this is good, keep talking. Yes, I agree
Laura,
with
you
that.
gonna make that motion?
So am I just making a motion on our choice of?
Well, it's up to you. You can make a motion, or I can read back or attempt to recapture what I said in the form of a motion.
read it
And then
back.
somebody can say so moved.
Read it back.
Or you can read
Yeah,
it back and
go
I
for
can
it,
write it
yeah.
down, and then I can.
I didn't actually write it down, so I lied. But
He can.
how about not me, somebody's going to make the motion, a motion to find that the board has jurisdiction to consider violation 1 to the extent that it is an enforcement matter that arises out of the land use ordinance, but not to the extent that it concerns enforcement of the shoreline zoning ordinance, because this is an enforcement action arising in part out of the shoreline zoning ordinance and in part out of the land use ordinance, and this board's land use ordinance gives it jurisdiction over those issues, but its shoreline zoning ordinance does not.
So moved.
I'll Second that.
Any discussion?
Second,
I seconded it.
all in favor?
Discussion?
Discussion?
I think we've discussed it.
Yeah.
Yeah, it's been discussed.
All right.
All in favor?
Okay, time for the other horse. Violation 2. Your turn. Talk about
Okay,
violation.
so violation 2 takes place in the shoreland zone, and the shoreland zoning ordinance clearly states that we have no enforcement action, or, excuse me, no jurisdiction over enforcement action in the shoreland zone. And violation 2 all takes place in the shoreland zone.
I'll agree, the book's black and white. And it all falls under that on page 42. It's very simple, it's cut and dry. I don't think we have any option but to deny number 2.
I concur.
Would somebody like to make a motion?
I make a motion that we do not have jurisdiction over violation number 2.
For the reasons just described.
Seconded.
All in favor?
So you've broken it up into 2 motions, which is fine. I think I've heard your factual findings to support that. What I would summarize is that the board's concluded it has jurisdiction to hear this appeal as it pertains to the portion of violation 1 that arises out of the land use ordinance, but does not have any jurisdiction beyond that. Okay. My suggestion is that I just want to clarify, I understand what the board is doing here and is making a tentative decision, so no final decision has been made tonight. So the reason I say that, and the reason I'm just looking at the attorneys for benefit of everybody else, is I don't want there to be any question that there's been a final decision tonight and there's some appeal that starts tonight. The board's made its decision on jurisdiction, but it's going to be part and parcel of the final decision that is reached on this appeal in the second meeting. So at this point, what I would suggest to the board is that I think the next item of business is to schedule the date for the continuation of the de novo hearing to consider the merits of the appeal and to set any deadlines the chair or the board might want to set for any additional submissions, so you don't have people like me giving you a memo at 6 hours before your meeting.
I would suggest that we only accept additional information up until 7 days prior to the date of the next hearing.
I'll agree with that. These last minute information just confuses things.
So I do believe the board has that authority under the board rules to establish a course of proceedings. So in my opinion, the board has authority to do that. You just want to make it a motion.
I'll make a motion, we don't receive any new information about these proceedings,
Any new written submissions?
any new written submissions, thank you, a week prior to our meeting.
And it's from the parties.
7
as well.
days or 7 days or 7 business days?
7 days, it's a week.
Second,
I'll second.
all in favor?
Hearing no objections or concerns from the parties about that.
That's fine.
That's fine.
All right, so what's a good date that is good for everybody?
We recommend December 10th.
What day is that on? I'm sorry, I didn't bring my phone in.
So might I suggest maybe, Mr. Jones, are there particular days that, December 10th was thrown out, so we can start looking at that, but are there particular days that this room is available?
I was looking through November and just from, certain staff being absent, and when you stated that you were out for the second half of November, I think November I couldn't find any day myself that November would work for everyone. So if it's okay with all of you, we might have to move it into December just so that we get everybody that's, relevant.
You had an option of the 10th.
I think the 10th, the 3rd or the 10th was open for, we didn't.
Normally, this building is, nobody's here Wednesday nights.
And those are both Wednesdays.
Yeah. Which one do you like, folks? The 3rd or the 10th? The 3rd is,
Either works for me.
I'm fine with that.
I'd rather do it earlier.
I'd
The
rather do it
3rd.
earlier as well.
Should I just mention that I have a tentative conflict on the 3rd. I could try to move it, but if the board is available on the 10th.
The 10th?
10th.
I'm
Does
okay
the
with that.
10th work for you folks?
Yes, it does. Right. We have a pending Freedom of Access Act request that we've submitted to the town. I anticipate that we will have received the responses to that by reasonably in advance, at least 7 days in advance.
I'm sure the town will make every effort to do that, so we don't have any
So-
delays.
That was one of the recommendations for the 10th, is to allow us to fulfill that FOIA request.
Thank you.
So if we get a timely response to that request, then the 10th should be fine.
Good. What time, 6 o'clock?
6 o'clock, yeah.
I'll make a motion, we have our next meeting on December 10th, 6 PM.
Second?
I'll second. Kurt seconds.
All in favor?
All right, the best motion of the night.
I'll make a motion to adjourn.
Second?
All-
This is very
All in
housekeeping.
favor?
7 days prior. Do you want to give us a time deadline on the 3rd,
End of day, or
5 p.m.?
7 days.
End of day is?
5 p.m.? Is there consensus on 5 p.m.?
Okay,
5 p.m.
That'd be
5 p.m.
Sure.
Sure.
All right.
Yeah, 5 p.m.
And our submissions will go to the chair and